right, Crim 4, let's knock out Chapter 8, Pretrial Motions, Hearings, and Plea Negotiations. Sounds exciting, I know. It is really kind of, but introduction prior to trial. Remember, trial is when the prosecution tries to prove beyond a reasonable doubt through evidence and with witnesses and all that kind of stuff, testimony, that the defendant is guilty beyond a reasonable doubt. Motions are filed before that with the judge. Accompanying the motion will be an affidavit, which is typically a document setting forth the reason that the judge should take some sort of action. Judge will hold a hearing before the trial and in which both sides can present evidence and they argue why the judge should rule a certain way. This will make a little more sense when we talk a little bit more about these pretrial motions. And again, pretrial simply means before the trial, okay? So discovery. Discovery is a fancy way to say evidence. Pretrial right of discovery. Each side, both prosecution and defense, have the obligation to share discovery or evidence with the other side. That's really what this means. If I'm the prosecutor, I have to share my evidence with the defense and vice versa. That's really all these 2 slides mean. Everybody has to share evidence with everybody else. Yeah, that's really it. Motion to suppress evidence. So before the trial, if there's some sort of evidence that one side or the other does not want to be presented in front of the jury, they're going to try to suppress that evidence or hold it out. We talked about the exclusionary rule already. So when they do that, they're going to try and do that before the jury gets seated so they don't actually see that evidence. They're going to do all this stuff before a trial. So the inadmissibility of unlawfully obtained evidence is known as the exclusionary rule, again, which we already talked about. Since that decision, the exclusionary rule, we want to, again, address that issue before a jury is seated. So this is going to be a pretrial motion where one side or the other, typically you're going to be a defendant who doesn't want certain evidence to get allowed into court. There's going to typically be a hearing where the judge will decide one way or the other as to whether or not the evidence is going to be allowed. And typically it's going to be the judge alone and not the jury. Confessions. Yeah, was a confession valid or not? Was a person beaten in order to get a confession? Well, they're going to address that issue before a jury gets there so they can decide whether or not that confession should be allowed. Was the search and seizure, was it a good search? Did they find, did they search somewhere where they shouldn't have searched in order to find certain evidence? Again, all those issues are going to be addressed pre-trial. If their smoking gun, their best piece of evidence, their only piece of evidence is tossed before the trial, then they may ask that the charge get dismissed. And that's what this is, nolo prosequi, basically saying you don't have any evidence left, so you can't go forward, and we want the case to be dismissed. Continuance. This is one because there's one side, it's really easy to ask for a continuance, and the other side not so much. And let me explain now. If I am a defendant and I am on trial for murder, and I want the case to be continued, I can tell my attorney, we need more time. My attorney says, hey, we need more time to get some new evidence. So let's continue this case for another 6 weeks so that we can get this evidence. And I say, okay, that sounds good to me because it benefits me. It's in my favor. I know I have a right to a speedy trial, but it's in my favor to wait those 6 weeks. So yeah, let's continue it. Okay? Because I'm the defendant. I'm the person who is on trial. But imagine I'm the prosecutor and my witness, my best witness, is in Jamaica for 6 weeks on vacation. And I need a continuance. Should the defendant be forced To sit in jail for an additional 6 weeks because my witness is in Jamaica on vacation for 6 weeks? It's not that easy. The defendant has a right to a speedy trial. And if the defendant doesn't agree to waive time, as they call it, agree to that continuance, too bad, so sad, I don't get that continuance. Does that make sense? And I hope it does. So as a defendant, as a person sitting in custody, you have a right to a speedy trial. So the prosecution really has very limited time constraints. As a defense attorney, you just tell your client, hey, we're not ready yet, so we're going to continue this, okay? And the defendant basically doesn't have any options because he needs his attorney to have all the evidence. Anyway, it's pretty frustrating. Motion for severance. This is another one, and it's so much easier, or so much more fun to describe this in person. But severance, motion for severance, there's two different ways to describe what this is. But and I'm going to describe both of them. Let's say that my husband and I got arrested together. I am me. Let's say, I'm just going to describe myself. Your average, middle-aged, white soccer mom, looks like a kindergarten teacher, never been arrested, whatever. Okay, that's me. My husband, on the other hand, this is not true, so don't go spreading rumors that Fernandez's husband's a gangster. But let's say my husband has a shaved head and he has a big Fresno State bulldog tattooed on his head. He has a B on one cheek and a D on the other in Old English. He has Fresno in Old English across the back of his neck. He's got some teardrops coming down from his eyes. He has multiple gang tattoos, and he's just a gangster, okay? But we got arrested together. We committed a crime together. When we go to trial, do you think I want to get tried at the same time as him, in the same courtroom as him? Would that benefit me? Probably not. I'm thinking that I don't want to be tried at the same time as him because people are going to look at him and automatically think that I'm guilty, even if I am guilty. So I'm going to file a motion for severance and say, please, judge, it would look bad for me to get tried with him, so I want to be tried separately. I know, that's crappy, but that is kind of a fact of the courtrooms. But so that's one type of motion for severance, okay? The next one, let's say, I was alleged to have embezzled some money from my employer, okay? And a couple weeks later, I committed another crime where I attacked an old lady at a bus stop. I punched her in the face, and I grabbed her purse, and I ran. Okay? So the first one is just me embezzling money. You know, I didn't hurt anybody. I didn't take any, there was no physical harm. I just embezzled some money. And my second crime, a couple weeks later, I punched an old lady in the face, and I stole her purse. They want to try me for both of those crimes in the same courtroom with the same jury. Would it benefit me to be tried for both of those separately? What do you think? Once they see a video of me punching that lady in the face, am I automatically going to be guilty of everything else? Yes, of course I am. I'm a piece of crap and they all know it. I'm going to want to be tried separately with separate juries. So I'm going to file a motion for severance. Make sense? I hope it does. But basically, I want to be tried separately, or I want my crimes to be tried separately. Okay? All right. There we go. Okay, competency. All right. Competency and sanity are two very different things. I know they sound very similar, but they're not. Competency addresses the person's mental status at the time of the court hearing, at the time of court. Sanity refers to their mental status at the time the offense was committed. Okay. So let's say this, just for example, I committed a robbery and I shot somebody, and I ended up, I ran from the cops, and as I was running from the cops, I got hit by a bus. When I got hit by that bus, I suffered brain damage. And I could no longer assist in my own defense in court. I was not insane at the time the offense occurred, but now in court, I'm incompetent because of the brain damage I suffered. Make sense? Okay. So insanity refers to the accused's mental health at a mental state at the time of the act. Competency refers to the accused's mental state at the time of the trial. So emotion in court at the beginning of the court process is typically going to be a motion to determine competency. So competency of the defendant must be determined because a person cannot be tried, sentenced, or punished if they're not, I should say, competent. I didn't write this. They're not competent. So a person who's incompetent is a person who cannot assist in their own defense or really understand the court proceedings. Okay, I'm going to go back to this because this is an interesting one. There was a case in Fresno County where a young sheriff's deputy, his name was Eric Tellen, was murdered by a man. I was up in the foothills here in Fresno County, and the man was definitely suffering some sort of a psychotic break. In the first, I think it took almost a year. He was initially found incompetent to stand trial for Deputy Tellen's murder, and then was sent to a mental facility where they brought him back to competency, shipped him back to court, and he was ultimately tried for Deputy Tellen's murder. So you'll see that the end result for insanity and competency is also different, but these are things that we're going to, again, talk about a little bit later on, too. Pretrial conference is something that happens before the trial, but this is ultimately when they're trying to work out a plea bargain. Okay, so attorneys are getting together, kind of trying to work out a plea bargain. What's a plea bargain? Well, it's funny you should ask. Plea negotiations. Basically, it's the prosecution and the defense, and they are trying to work out a way to resolve the case without taking it to trial. So what they usually do is kind of talk about, like, how can we resolve this in a way that keeps us all from having to go to trial together. Why do we have plea bargaining? Because there's absolutely no way that the courts could possibly try every single case that gets filed. It's just completely impossible. I kind of consider plea bargaining or plea negotiations kind of like that necessary evil. But a lot of times they'll do things like drop a charge, reduce a felony to a misdemeanor, things like that, in return for the person, the defendant, entering a plea for a lesser charge, for a lesser sentence, things like that. So let's say I'm charged with a felony vehicle theft. The prosecutor might talk to my attorney and say, if she pleads to a misdemeanor, I'll reduce it. I'll reduce this to a misdemeanor if she pleads out. And I'll say, sure, I'll take the misdemeanor. Done deal. Boom, boom. Win-win. Okay? It has been criticized. And I'll be honest, when I was in probably my early years at Fresno City College, I thought I wanted to be an attorney. But I knew I wanted to do criminal law because this was what really, really, really interested me. And then I realized how much plea negotiating went on, and it was just frustrating to me to watch. And it's necessary. They don't have a choice but to plead out a lot of these cases, which kind of made me feel a little bit jaded. And I kind of decided not to become an attorney for that reason. It has to happen. There is no other way around it. But plea bargaining is something that's, praised and criticized. But it can be frustrating. Sometimes prosecutors will overcharge just so they'll have the opportunity to negotiate a plea. And that's kind of unfortunate as well. But sadly, it sometimes becomes a game. Please should be blah, blah, blah. Yeah, I'm not going to skip through that. There have been instances where a plea negotiation or a plea bargain was worked out, and they go on the record in court, and the judge hears the plea bargain and says, absolutely positively, no, I will not accept this plea. I'm not in agreement with it. I don't believe in it. And so that can happen. Basically, a judge can break up a plea bargain. It has happened. I've seen it happen before. Plea bargaining can also be tied to someone's sentence. So like maybe a lot of times, especially for things like murder, prosecutors will take the death penalty off the table. So they'll say, okay, if you plead to first-degree murder, we'll take the death penalty off the table. So we will not ask that you be sentenced to death. Or, we won't ask that you go to state prison or whatever. So there's a bunch of different ways that you can use the plea bargaining or plea negotiations. Anyways, but yeah, the judges can absolutely break those up. Both prosecution and defense have the right to pretrial discovery, which is evidence. There are limitations as to what the defendant can have. That usually means personal information that they can't have. We talked about motion to suppress evidence. We talked about plea bargaining. Boom, boom, we're done.